free in your heads again, huh? I mean, if you're gonna spend your days obsessing over me, you might as well start calling me something respectable. Maybe Daddy Shizzy, or better yet, Papa Nut. Who's the grown up here? Alright, it's me. Let's go. Call me Daddy, yeah, that's who I am. Running your mind's like a master plan. Papa Nut, Shizzy Daddy, take your pick. I'm rolling in your thoughts while you still act sick. Call me Daddy, it's what you mean. While you chase the crust and I take the lead. Living rent free, that's my name. Go ahead, say it, put some respect on your name. Man, I'm too old, well here's a surprise. I'm the one with the brains while you're stuck with the lies. You act like you're experts, but here's the reality. I'm the one controlling your mental reality. So while you're out there trying to throw shade, I'm sipping coffee and you're feeling betrayed. You're mad, I got the spotlight, now it's my time. So why not call me Daddy or Papa with a rhyme? I'm the landlord and you're just the tenants, stuck in your headspace with no insight, no repentance. Call me Daddy, you know it's true. You'd be lost without me, stuck in the glue. Call me Daddy, I'm holding your mind while you're scrambling, trying to find what's behind. Papa Nut, Shizzy Daddy, don't you see? You're living in my world now, I'm the VIP. Call me Daddy, just let it be. While you're trying to figure out your own identity. Oh, I see you're confused, trying to get it right. Spinning your wheels while I'm out of sight. You think you've got it figured, but you got it all wrong. I've been running your minds all along. But sure, keep pretending you don't care. Keep saying you're done, but I'm still in the air. You got no choice but to bow to my name. Daddy Shizzy is here to own the game. You say you don't watch, but you're obsessed. Every word I say puts you to the test. Call me Daddy, Papa Nut, you know you should. Because I've been living rent free, and you know it feels good. Keep it up, keep trying, but you'll be stuck with Daddy for life. I'm Papa Nut, Shizzy Daddy, owning your headspace, and there's no escape. Good luck with that.
Hello, Raiders. Man, you just can't even take a slight bit of a break and everything just goes to absolute bonkers. Man, oh man. Welcome, Raiders. Welcome, welcome, welcome. It's gonna get crazy. Mug Raid, good to see you. Jack's mom, Happy Witch, good to see you, Patty Sewell. It's wonderful. Everybody, welcome, welcome, welcome. Yeah, we're probably gonna dig into this because there is so much to unload tonight. I mean, it is just a plethora of stuff. Plus, I have a new song and I have a new letter that's going to be going out to it's another open letter to Bubbles, so be prepared for that one. It's going to get a little weird, a little wacky, but be prepared because it might go a little long tonight. It's not long like last night, you perverts, but we're gonna have a good time tonight. I'm looking forward to this one because the 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 judge made a ruling. Randy Shockett filed a motion. That motion right there, we're gonna go over, and the amount of stuff to unload in that is insane. Plus, what the judge put in his order is going to be going. We're going to be going over that tonight. Our favorite open letter to Bubbles. Oh yeah, it's going to be a good one. It is a quite a long letter too. So I hope you're prepared for that one. I've been having, oh, too much fun with it. Just too much fun. Welcome, welcome, Raiders. Welcome, Vicky Brushwood, Carol Anderson, anybody that I missed. I'm sorry. The chat just goes zipping by there like so fast. Welcome, welcome, welcome. We have some wonderful mods here tonight. I I what I saw these come in. I had finished work today and was just like, I'm going to check and see if anything came in. And oh my God, it sure did. Well, thank you, Max Lab. Yes, Max Lab. Thank you. Thank you so much. Yeah, as soon as you reached out and sent that one, I was like, holy crap, there's more. There's more. Thank you, Max Lab. I appreciate you. Appreciate you so much. That is so swell of you right there. Right on the top, right there. Mm, mm. Yes, it is going to the amount of stuff that I have to unload is insane. We might go a little bit long tonight, so I hope you guys can hang for that. But I will put the letter in there at a really nice spot. It's going to be a sweet spot for it. Welcome, Mug and Tug Raiders, Megan and Tug. You guys are awesome. Hell yeah! Happy birthday, Mr. Max Labs. Welcome. Well, happy birthday, Max Labs. That's awesome. I did not realize it was your birthday, and we've also got another one, $2 from Death Angel. Hey, Daddy, hugs and loves from everyone to everyone. This is a place to come to have a little bit of fun, get get some of that anxiety out because we don't keep anxiety here. We keep it kicked out on the curb, just just like never mind, we won't say that. Thank you very much. I appreciate you, Death Angel. That's wonderful. Is and again, happy birthday there, Max Labs. That's wonderful. Oh no, you haven't missed the letter yet. The letter will be incoming. We're going to break down some of this right here and
Puzzled
right
Puzzler
before we
donated
get into the
$19.99
oh
through
my
Super Chat.
gosh.
This is the case that never ends.
Oh my
Yes,
gosh.
it goes on and on. My friend, some people
All
followed it not
right.
knowing what it was, and they'll continue it forever just because this is the case that never ends. Yes, it goes on and on. IFR.
Thank you so much, Puzzled Puzzler. 1999. Oh, that thank you so much. This is the case that never ends. Yes, it goes on and on, my friends. Some people following it, not knowing what it was, and they'll continue it forever just because this is the case that never ends. Yes, it goes on and on, my friend. That's awesome. Oh, thank you, Puzzle Puzzler. There you go. That is, yes, and I agree. It is a case that just goes on and on and on. It doesn't seem to stop and just gets crazier, crazier every single time. Your birthday was in January. I don't know. Someone said, well, happy birthday, Max Lab. Well, happy birthday again, belated, but congratulations. Welcome, welcome. You'll still here, but mostly be lurking. Well, that's good. That's good. It's okay to lurk because we have a good time. Can you believe Deuce emailed whatnot? Yeah. Yeah. That gets really, really crazy. And I will go through all of that. I did read this a little bit earlier, but there's if there's new information that I glean out of this, that'd be awesome. So let's go ahead and get into the first one before I get to the and I will tell you I did get a short video for this, and I'll play that a little bit later on, and you get to see the newest video. I haven't released it out to anybody else yet, so you get first glimpse of it, but you're gonna have to wait till after this one, and then I can get that video up, and then I can get everything geared up to read that wonderful letter. Hey, how's it going, Lady Fox? Good to see you, Photo Lady. Good to see you. Good to see you, everybody. Wonderful, wonderful, wonderful stuff tonight. Mm, and we'll go ahead and we'll get started with this one right here, which is the response to defendant's second motion to dismiss under FRCP 12 for lack of subject matter jurisdiction. The plaintiff, Jeremy Brian Hales, in accordance with Local Rule 7.1E, responds to defendant's second motion to dismiss under FRCP 12 for lack of subject matter jurisdiction, document number 67. States defendants seek a second bite at the apple by following the second motion to dismiss, attacking the amount in controversy only. And that's exactly what they're doing. Defendants argue that the amount in controversy can no longer be satisfied due to the dismissal of plaintiff's extortion count and plaintiff's purported admissions. So what he's talking about is they're wanting to get it dismissed because there's just no, you can't, it doesn't qualify for that right amount of money, which would be that 75,000. Now, the reason that Randy wrote this as the motion should be denied as it's plainly without merit. The existence or non-existence of the amount in controversy required by subject matter jurisdiction is determined on the basis of the facts and the circumstances as of the time that an action is commenced in a federal court. And what Randy is pointing out here is his motion, document number 67, his motion to be dismissed because or have it moved to a state court is because this was already established at the very beginning of the case. And he says, under easily stated, well settled principle, reflects in cases throughout the federal courts the existence or non existence of the amount in controversy required for subject matter jurisdiction is determined on the basis of the facts and the circumstances as of the time that an action is commenced in federal court. And here he is, right there, 14B, Charles Allen Wright, Arthur R. Miller, Federal Practice and Procedure, and he has all of the legal documents to provide that his same recommendation why this shouldn't be moved to state court. The dismissal of the extortion count does not defeat diversity jurisdiction at this stage of the case. Events occurring after the filing of the complaint can reduce the amount recoverable below the requisite amount do not oust the court from jurisdiction. And he's citing all of the case law there. Subsequent amendments to the complaint or dismissal of certain claims, even if they reduce the demand below the threshold of $75,000, do not ordinarily oust diversity jurisdiction as long as the original demand was made in good faith, and this is due to the Federal Practice Guide. A claim made in excess of the requisite amount made in good faith and the complaint satisfies the jurisdictional requirement. Events occurring after the filing of the complaint that reduce the amount of recoverable below the requisite amount do not oust the court from jurisdiction. And he omitted the citations on that. The court has already determined that the original demand was made in good faith. And right here, there are few accusations that can be more harmful to a person than false accusations of essaying others, especially children. That is particularly true when the falsely accused person's business and source of income are directly tied to the number of people who view, support, and subscribe to his social media content. It is not difficult how being falsely accused of raping child along with other defamatory statements defendants have allegedly made, could cause plaintiff to suffer damages in excess of $75,000. And then he gives the citations here. Refusing to set aside $8.2 million defamation jury verdict where the defendant falsely stated in public advertisement that the plaintiff had solicited underage girls for sex. Now, he goes on to saying awarding the plaintiff $700,000 in damages for defamation where the defendant referred to the plaintiff publicly as an adult perpetrator and like a child assayer who had masterminded an attempted premeditated murder. When possible actual damages are combined with the possible treble damages and the possible reasonable attorney's fee, the court easily finds it is more likely than not the amount in controversy exceeds $75,000, and he refers it back to Doc 14. He also states the motion should not be well taken. Even the statement in paragraph 19, okay, because you notice that the fleas over there have been yelling about paragraph 19, which focuses on repeated defamatory posts, which the plaintiff has seen was made in good faith. In fact, plaintiff's statements about defendant's defamatory social media posts he has seen as evidentiary value and is uncontroverted. It is axiomatic that the troubling social media posts, such as those which accuse someone of being any kind of child predator, would be deleted by the publisher. In fact, defendant Preston has already deleted her entire Facebook group called Otter Creek and Friends, and they think deleting these things is going to absolve them from these kinds of issues, which prior to being deleted contained a social media post from defendant Preston to plaintiff that stated, I am not a whore, Jeremy. I have never slept around. That's why I was married so often. Okay. John is his own man. I don't know why Jeremy attacks me due to John's behavior when he knows the truth. Again, we do not live in filth or a garbage dump. I do not have never, not ever beat my baby daughter. Shame on you, Jeremy. Well, there's proof against that, according to a 911 call. There's proof on that she has threatened her daughter by slapping her in the mouth. John is not a sex offender or a PDF file, but I find it funny that you hang out with men that are, and you yourself are disgusting towards children, mainly focusing on little girls' crotches. Really? This right there is just, again, doing the same exact thing that she said. Oh, I'm not doing that. I am my own person. Well, see Exhibit 1. Now, Exhibit 1 is pretty straightforward. It has her own admissions, 8/20/2023. All of the same things that she posted right there. Defendant alleges that plaintiff fabricated these allegations out of thin air. Document 68. Now, you have to remember document 68 is where where Bubbles put in there that the plaintiff fabricated these allegations out of thin air, that she never did any of that. In reality, defendant Preston made her defamatory statements about the plaintiff disappear into thin air, which means she deleted that particular channel, hoping that it would go away. The only problem is those were all screenshot. And discovery continues. This shows that the motion should not be well taken, as it simply would permit a party who has already been shown to delete their own posts and an entire Facebook group made in social media to falsely claim that their opponent is being untruthful when they state that they saw defamatory posts before they were deleted by the publisher. Furthermore, the complaint does not hinge on whether or not repeated posts are made. Regarding the motion's claim that plaintiff cannot identify a single person who saw defamatory signs other than Zim Paget, Therese Granger, or Stephen Granger, defendant's counsel disproved this himself recently in the deposition of Miss Amanda Martin. Defendant Preston's court-appointed victim's advocate, an employee of the 8th Judicial Circuit in the state of Florida, who testified that she saw the signs when social media posts and links to those defamatory signs were sent to her by two different people via email. See transcript exhibit number 2. And here we have exhibit number 2, which says United States District Court for the Northern District of Florida, Gainesville, and it shows the case, shows the defendants, shows the plaintiff. And now these also, it is quoted in here, excerpts from the deposition of Amanda Martin, because this is not the whole deposition. These are just the excerpts from it. Elemental P plus R is a monster. Yes, indeed, she is. Examination of the witnesses taken before, and it tells who they took it on behalf of, right here it goes. Whereupon Amanda Martin acknowledged having been duly sworn to tell the truth and testified upon his or her oath as follows under direct examination by Mr. Shockett. In your office, did you hear about any road signs around town in Otter Creek? Response was no. Question, you just heard there was a case. Response was yes. And now during cross-examination by Mr. Manskin, do you have any knowledge about the road signs, handwritten signs calling Mr. Hale the child rapist? And the response from her was, to be very honest, only through some of these YouTubes that have been sent to me and all this, I didn't know anything about any of that when this was going on. So just since that, what compromises your knowledge about this topic? Is it just seeing YouTube videos? Answer, that is it. On your own, or do you say people send them to you? Yeah, I do not go and look at that. Question: who do you receive? Who do you receive? Who do you receive those YouTube links from that prompt you to watch something? The answer is, I could not tell you by name. I just have some very bored friends in life. That's just what they do. They thought you might be interested, so they'll send it along to you, particularly with this whole "What's the Hale Bad Neighbor" response. I call it a saga. But yes, what do you call it? I call it a saga. Question: so you don't have any knowledge other than what you just described, just watching some video clips on YouTube? The response is, yeah, a very minimal at that. I don't have any knowledge of any size. Certificate of reporter, and that is the end of it right there. So she has seen, under her own admission, that this has been posted on social media. Regarding anyone contacting Whatnot Incorporated, which is what Jeremy argued in the first place whenever they were saying they've gone after my business on YouTube, they've gone after my business in other places. This right here is what was brought out by Bubbles himself. Regarding anyone directly contacting Whatnot Incorporated to use defamatory statements to interfere with plaintiff's relationship with Whatnot Incorporated, again, defendant's counsel has recently provided such evidence. This is evidence that Bubbles is creating himself. Welcome, number 330. Yeah, hit that like and subscribe. Again, defendant's counsel has recently provided such evidence. This occurred Monday, February 17th. What is today? Today is the 19th. So on the 17th, defendant's counsel emailed Mr. Cam, a Whatnot representative, and stated, oh, Mr. Cam should know that you are dragging him and his company into your client's scam of contrived litigation to create YouTube content for your client's storylines. Why don't we just pull up this piece right here, which is saying right here, here's Deuce reaching out to Whatnot contracts, stating, Mr. Shockett. Oh, well, let's get down to the actual email that was sent in the first place. The email that was sent in the first place is, see if we've got it here. No, the email that was sent out in the first place was 17th at 8:19, and this is at 9. Okay, so at 8:19 in the morning, February 17th. This is, I believe, coming from somebody from What the Hales. It says they wrote, "Hello, Mr. Cam." Oh, so that would be either Shockett or Doreen. Say, "Hello, Mr. Cam. I represent Jeremy Hales. Mr. Hales is a plaintiff in a federal lawsuit in which the defendants have requested that the agreements between my client and Whatnot be produced. The contract, as you know, requires the written consent of Whatnot in order to be produced, and also requires it to be produced pursuant to a court order. We currently don't have a court order, although I have suggested to my opponent, which is Attorney Manskin, which is copied here, that we simply agree to such an order. There has been no proposed order from my opponent. Attorney Manskin has requested that our firm draft a confidentiality agreement, and we will be doing so this week. We anticipate this will be signed, but please advise as to the written consent of Whatnot. Thank you. And if you have any questions or concerns, please do not hesitate to contact me. Right here is a straightforward letter saying that we're drafting a confidentiality agreement. We're going to have it out this week. We anticipate that this is going to be signed by plaintiff's counsel. That way we have this in writing. And that way, whatever you release to us, we're going to make sure that is not exposed to everybody else in the whole YouTube verse or on other platforms, whether it be, you know, Twitter, it's not being slammed out there. You don't have to worry about it. This is a confidentiality agreement. What information comes in, so that way we can provide proof of the BS that has been perpetrated, how much business he's lost, and people that have been reaching out to whatnot. We would appreciate your help in this matter. And the opposing counsel doesn't say anything bad about opposing counsel, doesn't say anything horrible, just says, this is my opponent on the other side. And they're copied on this email. You can see this whole email yourself. Sincerely, Randy Shockett. And what is the response that Dimwit has here? Instead of responding to that, he responds to Mr. Shockett and says, I do not know what machinians you're orchestrating by copying me on this communication. I have no obligation to provide a proposed order of confidentiality. That's not what he said. Although I did specifically provide a stipulation to maintain confidentiality in writing, but you ignored that because your purpose has been to exploit the issue of production of this contract for as long as possible in order to waste time and create issues for court motions to generate YouTube content. Mr. Cam should know that you're dragging him and his company into your client's scam of contrived litigation to create YouTube content for your client's storylines. Mr. Cam may be interested to learn that as part of you and your client's litigation scam that you're now trying to involve whatnot. And I just have to point this out because why would Mr. Cam be interested in this? Because the only thing that Mr. Cam would be interested in is simply providing the information that has been requested by the court. The court has said you need to turn over these financial documents so you can provide proof of loss of income. That's what we want you to do. So why would he's not trying to involve whatnot in this? Whatnot is involved in this in the first place. No different than YouTube's involved in this. No different than any of his other businesses are involved in this. What in the ever-living F is Bubbles thinking? Or I must say he just doesn't think. He committed perjury to trick federal court into exercising jurisdiction by filing. Now, this right here is where it goes absolutely off the freaking bonkers wall. Into exercising jurisdiction by filing a false affidavit stating my clients made and were making online. This right here, Mr. Cam. Mr. Cam does not care about this. All that Mr. Cam cares about, the only thing that Mr. Cam should care about, none of this crap right here that he's throwing out. This right here is in posting this crap right there sounds to me like he's defaming again, yet again. Filing a false statement, affidavit, state my clients made or were making online posts calling him a child predator constantly and ongoing to this day. And your counsel did nothing to confirm whether there were such online posts before you signed the motion opposition that relied on a perjured statement. Whoa. Like, slow your roll, cheese puff. Jeez. He copied this. Yes, Kathy. He copied this to Mr. Cam. Why would you send this kind of stuff? This is defamatory even more so. I would think any company would want to know if they're prominent. Oh, and here he is, right here in this right here is trying to get him removed from whatnot. By creating this defamatory language and sending this to Mr. Cam, this right here is more defamation. I am so surprised that I will not be surprised if the judge sees this and actually reads this and goes, "What in the ever living hell are you doing? I told you weren't going to be part of this case, but you've entered yourself into this freaking case by doing this kind of crap." Cheese puff. Jesus. And here he states right there, "I invite Mr. Cam to reply here, stating whether he or anyone at Whatnot has any information about either of my clients." Whatnot is an online auction. This is a business. What does this have to do with anything? Or anyone else contacting Whatnot for the purpose of attempting to interfere with Jeremy Hale's What the Hell's business with Whatnot, and Mr. Cam or someone on behalf of Whatnot would call me. No. No, you do not. If Whatnot is hearing this, don't you dare call this bastard, because he will twist everything that you say. It has to be in writing. Every single bit of this must and has to be in writing. Every bit of it. Do not trust a single thing that this guy is telling you. Because one, he's going to spread it all over Facebook, all over YouTube, all over whatever platform he possibly can to disparage Jeremy Hales, as he's doing right here in this. Mr. Cameron, someone on behalf of Whatnot would call me, so I may inquire about that single question. I think there would be no need for me to subpoena him or Whatnot for documents or deposition. Why would you have to? If they provide that information, that's that's as good as an affidavit of saying, "Hey, you're costing my client money, and you're doing it again just by defaming him right here. Mr. Cam may reach me at blowjob hole if he prefers. I invite him to call me along with Whatnot's legal representation, or forward my name and number to the appropriate person to contact me, as an informal call should be all that's necessary to avoid further involvement in this nonsense that you're trying to cause with your email." He is, I'm sorry, that is the most asinine BS. And whatever thing that he has been snorting up his nose, he needs to stop. Because this is the absolute worst thing that you could be sending out to somebody. Especially if you're sitting there going, "I'm not defaming now." You're doing it again. Oh my. This in of itself should be enough to get BBB disbarred. I don't know about disbarred, but it should get him sanctioned. This right here should get him sanctioned for he's told by the judge, "You need to provide this information of where you're losing business." And whenever he reaches out, includes co-counsel on this and says, "I'm including you on this so you're aware of the conversations that we're having, acting in a professional manner." Then here comes Mr. Sniveling Sourpuss himself, comes crawling up in there and starts defaming him some more. Good God, man. Have you no scruples whatsoever? I guess not. I think he just likes the abuse. That's gotta be what it is. Good Lord. Defendants also purport to know that there were 41 minutes of daylight before the signs were removed, also in Doc 68. This evidence that defendants are protesting too much from Shakespeare's play Hamlet, "Thou doth protestest too much," because only someone who knew the date and time when these defamatory road signs were placed would make such a statement. Defendants' case law citations are unavailing at best and misleading at worst. Defendants rely on Shanahan versus Cahill, but is easily distinguished from this case. Shanahan involved a case where, after all other counts were eliminated. The sole remaining count was for an amount certain in liquidated damages, which irrefutably fell below the minimum amount in controversial threshold. The trial court felt compelled to dismiss all of plaintiff's claims when one count was eliminated and the remaining liquidated damages totaled less than $50,000. Nevertheless, the Fourth Circuit reversed the lower court's judgment and remanded and held that the lower court had discretion to retain the remaining counts. Defendant also purported to quote from Rosado v. Wyman by stating, in quotes, in particular, it is important to consider whether the amount claimed in the complaint was made in good faith or whether plaintiff was consciously relying on flimsy grounds to get into federal court. Now, emphasis is on the defendant's motion. However, upon reading pages 404, 405 of the opinion in Rosado v. Wyman, the purported quotation does not exist. So he misquoted exactly this right here. This right here is what his quote was, but this doesn't exist. It says right here, on remand, the district court correctly considered mootness in a factor affecting its discretion, not its power, and balanced the policy considerations that have spawned the doctrine of pendency and the countervailing policy of federalism, the extent of the investment of judiciary energy in the character of the claim. Not only had there been hearings and argument prior to dismissal of the constitutional claim, but the statutory question is so essentially one of federal policy that the argument for exercise of penitent jurisdiction is particularly strong. Respondents analyzed dismissal of mootness to dismissal for want of substantial claim and rely on language in United Mine Workers v. Gibbs to the effect that a federal court should not pass on a state claim when the federal claim falters the threshold and is dismissed before trial. So he goes on to show every single part right here. District court should be considered without discretion as opposed to power and hear a pendant claim, and we think the respondent's analogy fails.
Tracy Wilden
Unlike
donated £10 through
insubstantiality,
Super Chat. BBB is batshit
PPP
crazy.
batshit
I hope the court does something soon to
Yes.
shut that twant up. And yes, twant is a word. Lol.
JC for the 10. I appreciate you. That is so kind of you. And whenever I start getting a little bit further on, I'll pause reading the super chats, but I will read all the super chats. Thank you so much. 10 from Tracy Wilden. BBB is batshit crazy. I hope the court does something soon to shut the twant up. And yes, twant is a word. Thank you so much right there. That is awesome. I would have said it a different way. And as we go down here, the particular words that motion relies upon when citing Rosado v. Wyman as in being supportive of their motion does not exist in the cited Rosado v. Wyman opinion. So he misquoted the opinion by consciously relying on flimsy grounds to get into federal court. Appears nowhere in the Rosado Wyman opinion. Consciously does not appear in the cited Rosado opinion. Relying on flimsy grounds does not appear in the cited Rosado Wyman opinion. Good faith does not appear in the Wyman Rosado opinion. Defendants have obviously fabricated these phrases from whole cloth while presenting them as purportedly being from the United States Supreme Court opinion. Exceptionally, defendants' use of quotation mark misleads this court into thinking that this is a direct quote from the cited opinion. This also should not be well taken. Moreover, this is not the first time defendants have done this while attempting to argue the minimum amount in controversy. They did it right there. Defendant has made a bare bones allegation. The complaint has no allegation establishing the minimum amount in controversy for federal diversity jurisdiction motion at paragraph 3. In doing so, defendant misstates and represents the law to this court by citing to an opinion which does not exist. Defendant's misrepresentation should not be well taken by this court. The motion states C and points those out. And it still contains no such statement and is an order denying consolidation. See Doc 8 and 9, emphasis in the original. See also Doc 54 at notated 1. Even if defendants had not misquoted from Rosado, that opinion is nowhere analogous to the facts of this case. This is because Rosado v. Wyman, the Supreme Court held that the district court retained jurisdiction over a pending claim after a declared moot. A constitutional claim, Rosado v. Wyman, is not based on diversity jurisdiction and the amount in controversy. Damn, Doreen, Shockett, you guys are awesome. In fact, the unsubstantiality addressed in the cited Rosado v. Wyman was that of a federal question, not the amount in controversy. Conclusion: for the reasons above, it is respectfully requested that defendant's second motion to dismiss under FRCP 12 for lack of subject matter jurisdiction 67 be denied. And of course, he certifies it, and that was today. That was today that he certified that. So that went out today. All right. Whew, that's a lot to get through in 41 minutes. All right. So what we're going to do is we are going to play you a nice new video, a happy new video, and the one that I wrote the song for the other day, and it's going to fall right in play with what the judge filed today. Are you ready for it? Are you ready for it? Hit ones in the chat. I see enough ones in the chat. I will fire this video up. It is good.
Aletta has become a member. I
Hey,
enjoy your
Allegedly.
awesome letters to BBB. Awesome letters and tunes.
Thank you. I do have some. Portia was not so stinky has to kiss salamander. Okay. It won't be enough to cover his legal costs, but mostly wants peace. Yeah. All right. So this song, now you heard a version of it yesterday, but this is a completely different version, and it is going to be awesome. So I hope you like just a little bit of beat 3. Yeah, I'm seeing the ones in chat. Let's fire this bad boy up. Here we go. We are going to hide myself, and I'm going to show you guys this video.
Yo, Bruce. You keep catching L's like it's your 9 to 5. Out a weak ass motion, judge said nah, nice try. Courtrooms laughing, Gainesville smirking. You out here begging, but the system ain't working. Bruce hit the court thinking he'd get a dub. Found some weak shit, got smacked like a scrub. Tried moving courtrooms, judge ain't amused. Said we already in Gainesville, why you so confused? Crime by prejudice, bitches your own damn mess. Foul and trash motion, just stacking up stress. Ain't nobody read it, didn't need no reply. Judge saw the title and said denied. Bruce keep crying, but the judge ain't budging. Another bad motion, another ass thrashing. Your dumb ass pleadings make my head hurt. Gainesville to Gainesville ain't never gonna work. Jerk. Jerk. Judge looked at the brief like, what the F is this? No merit, no case, just legal nonsense. Said Bruce, I don't know why you wasting my time. Every motion you file, just weaker than the last crime. Talking about strategy, nah, it's just cope. Like a crackhead trying to sell bars of fake soap. Every single move, just a courtroom joke. Denied, stamped hard, now your ego got choked. Bruce keep crying, but the judge ain't budging. Another bad motion, another ass thrashing. Your dumb ass pleadings make my head hurt. Gainesville to Gainesville ain't never gonna work. Jerk. Yo, Bruce, what's next? Gonna file again? Trying to move court to the effing Caribbean. Judge don't care about your salty ass tears. Gainesville's locked in, say goodbye to your fears. Goodbye to your fears. Say goodbye to your fears. Goodbye to your fears. Mick Phillip and Paint Chip, they riding your wave. Both looking desperate, trying to get paid. But this ain't no payday, this a legal beat down. You a joke in the system, a certified clown. Shock it, just styling, dunking on your name. Each motion you write just fuels his game. Stop filing this bullshit, take the L with grace. Lady Doreen finna body bag your whole damn case. Bruce keep crying, but the judge ain't budging. Another bad motion, another ass thrashing. Your dumb ass pleadings make my head hurt. Gainesville to Gainesville ain't never gonna work, jerk. Bruce, take the L, sit your ass down. Keep sitting there mad, looking lost in denial. So next time you think about dropping some trash, just remember Judge Minty Fresh gonna put a boot in your ass. Your ass down. Keep sitting there mad, looking lost in denial. So next time you think about dropping some trash, just remember Judge Minty Fresh gonna put a boot in your ass.
Oh yeah, oh yeah. Man, that one. Why scold Randy? Well, there's a reason why he scolded Randy. It's very intentional why he did that. It wasn't because of anything that Randy did wrong. Sort of. But are you ready? Ready for the letter? You ready for the letter? And I'm giving it away too soon, aren't I? I'm giving away that letter just a little bit too soon. Oh my, oh my. We've got to get it tuned up. Get strapped in, boys and girls. We're gonna have this letter here shortly. The open letter. The bubbles. Mm, mm, my, oh my, oh my. Here we go. Another open letter to Bubbles. Let's make it happen. Here we go. Oh, yeah. An open letter to Bubbles, Manskin. The art of getting smacked down again, and the court's favorite punching bag. Dear Bubbles, the discount lawyer extraordinaire. Once again, you've graced the federal court with yet another pathetic, desperate, and legally brain-dead motion, only for it to be slapped down so hard it probably left a bruise on your ego. Not that you have much of an ego left at this point. That thing's been beaten down more times than your bar credibility. And this time, the judge didn't even waste oxygen entertaining your nonsense. He took one look at your whiny-ass little motion and he tossed it into the legal dumpster like a moldy bologna sandwich. The court didn't even bother asking for a response before curb-stomping your request into oblivion, and the judge has taken your motion, tossed it in the trash, and sent you back to the kiddie table where you belong. Bruce, this is getting sad, like really sad. Watching you flail around the courtroom like a demented circus monkey, filing these useless motions is almost entertaining, except for the fact that you're wasting taxpayer dollars with your sheer incompetence. So let's break down your latest humiliation. The judge didn't misunderstand your motion, Bruce. He recognized it for the garbage it was. You tried to whimper your way back into relevance by claiming to the court that you was mischaracterized your request. Bruce. The court didn't mischaracterize anything. You wrote it that way, dumbass. The judge just had the misfortune of reading your incoherent babbling and treating it exactly how it deserved to be treated, like legally worthless trash. Your reconsideration motion should have gotten denied faster than your legal career should have been. You actually thought you could cry to the judge to fix your own, we'll say, failure. Adorable. You blew it the first time, Brucey, and instead of just accepting your incompetence, you doubled down and demanded a redo, and the court's response, no. Sit down and cry, not just no, a humiliating, devastating, soul-crushing no, and not just any no. This motion is so stupid, I don't even need a response before I kill it with fire no. The judge actually had to spell it out for you like a kindergarten teacher explaining the alphabet. Bruce, Bruce, Bruce. The judge literally said he doesn't know why you even filed this. Do you understand how bad that is? That's like a doctor looking at a patient and saying, I have no idea how you've managed to survive this long. The judge basically told you your argument was nonsense from the start. You completely misused the motion for reconsideration. You wasted everyone's time. And best of all, nothing has changed. Nada, nothing, zero, zilch. Your original motion was dead, and this motion was just the bloated, rotting corpse of your first failure. Well, I know you and the Cankle twins will try to spin this as, but Shockett got slapped too, and that's the best you've got. Oh, Bruce, you're grasping at straws so hard. I'm surprised you haven't sprained that limp wrist. Yes, the judge also told the plaintiff's attorney to calm down with summary judgment filings. Yes, he did. Big deal. It's like handing out a parking ticket while simultaneously executing someone on the courthouse steps. And Shockett got told to wait his turn. You got publicly humiliated in federal court again. So if you think this is some kind of win for you, that's like saying the Titanic only had a minor accident. And more of Bubble's greatest hits. It's a career of legal embarrassment at this point, Bruce. You're not even a real lawyer. You're a cautionary tale. You file motions so stupid that judges have to hold back their laughter. You have no real arguments. So you just throw tantrums and legal briefs and hope for the best. You think repeating the same failed strategy is going to work for you if you just try again with a different title. Well, let's not forget your greatest legal disaster to date, the infamous Gainesville to Gainesville motion. Oh, how you must lie awake at night, drenched in sweat, haunted by the blues song that broke your little spirit. Bruce, how did you think that would end well for you? You literally tried to move a case that was already in Gainesville to Gainesville. You know what this reminds me of, Bruce? Your little tantrum over that Gainesville to Gainesville song. You remember that? The song that broke your spirit, the song that reduced you to whining in court filings, the song that proved you have the emotional resilience of a wet tissue paper. Well, it looks like this ruling just gave you a whole new reason to cry your little self to sleep. And when the judge laughed you out of that room, you responded with another motion begging him to reconsider. And now you're out here pretending that this is about convenience when it was really about you being a manipulative little weasel. So what's next for you, Bruce? I assume your next legal move will be to file another doomed motion, cry about it when it gets denied, blame everyone but yourself for being a legal failure. And you're going to continue whining about how mean the internet is to little old you. But let's face it, Bruce, you don't actually care about winning the case. That would require having a case to begin with. No, your only strategy is to drag this out as long as possible and hope that something sticks. And everyone but you is aware that nothing is going to stick. You are legally, professionally, and intellectually outmatched at every turn, and no amount of whining, grifting, or pathetic legal gymnastics is going to change that. Bruce, your career is over. Just accept it. Look, man, you're done. You're legally worthless. This case isn't going to save your reputation. It's just going to cement it as one of the biggest legal disasters in your recent history. So take this brutal, humiliating, and completely deserved loss and shut the F up. Because the only thing that's more pathetic than your legal career is your refusal to admit that it's already dead. Sincerely, Shizzy Wiznut, still your daddy, Still the one reading your legal obituary in real time. Thank you. Thank you very much. Thank you very much. And I can't help but laugh. Oh my gosh. The internet will forever be mean to him. Just dropped a tune on Suno Call Denied. It speaks for itself. Yes, audio coffee. Vicky, thank you. This is bad for Jeremy. This cannot happen. What? What do you say? Vicky, thank you. This is bad for Jeremy. This cannot happen. Jeremy worked so hard and spent so much money. I just cannot believe the courts would call it quit. That can't be possible. They didn't, Debbie. They didn't call it quits. Gotta love the blues. No, the court didn't call it quits. There's a very, very specific filing that came out, and this was an order by the judge right here, right here. So calm yourself down there. Calm yourself down. It's okay. It's okay. Oh, thank you. Thank you. Tissimo. Okay. So presently before the court are plaintiffs' motions for summary judgment as to the defendant's counterclaims and supporting memoranda. So these were docs 73, 74, 75, 76, and 77. Now, for the reasons below, the court will strike plaintiffs' motions for summary judgment and supporting memoranda. Okay, so you'll probably notice that the court struck out 73, 74, 75, 76, and 77, which were filed over the weekend. After the motion to dismiss was granted in part of Doc 63, defendants answered plaintiff's complaint on February 8th, 2025, Docs 69 and 70. In their answers, defendants asserted 3 counterclaims against plaintiff, including intentional infliction of emotional distress, unauthorized use of defendant's likeness under Florida statutes 540-08, and 3, common law invasion of privacy by unauthorized publication of defendant's likenesses. Now, this is going back to that thumbnail case. A mere 3 days after defendants asserted their counterclaims, defendant filed motions for summary judgment and supporting memoranda, primarily arguing that the defendant's counterclaims fail for lack of evidence. Docs 73, 74, 75, and 76 and 77. The deadline to file dispositive motions in this case, including motions for summary judgment, is April 28th, 2025. And that was from the judge right there telling you in Doc 37 at 2. Yet both sides, plaintiff and defendants, have now filed summary judgment motions before the full development of a record as to the claims and counterclaims at the issue. The court is concerned that both parties are filing early summary judgment motions with plans to file more summary judgment motions later in the litigation because it consumes substantial judicial and litigant resources early in the game. This is a piecemeal strategy of filing motions for summary judgment near the inception of the claims and is highly disfavored by the court. Okay. And he quotes it all right here. We certainly do not approve in general the piecemeal consideration of successive motions for summary judgment, since defendants might well normally be held to the requirement that they present their strongest case for summary, and Fifth Circuit Court decisions issued on or before September 30th, 81 are binding precedent in the 11th Circuit. Okay. That's what the little quotation was there. Will normally be held to a requirement that they present their strongest case for summary judgment when the matter is first raised. In this circuit, successive motions for summary judgment are disfavored. Okay, that's all statute that he's quoting here. Now, he states also here, other federal courts routinely prohibit successive summary judgment motions and provide litigants with one attempt at summary judgment. And we go down here to 2, in which he quotes all of the basis for why he says this. Okay, that's all it is. Filing service of multiple motions for partial summary judgment is prohibited absent prior permission of the court. So you have to ask permission of the court to file these summary judgments. Okay, that's what he's saying here. And while successive motions for summary judgment are not prohibited by federal rules or controlling case law, a second motion for summary judgment is not permitted as of right because successive motions promote piecemeal adjudication and erode judicial economy. Okay. So these are all the quotations of what he has right there. The court has inherent power to maintain control over its docket to ensure effective justice and prevent congestion, which basically all this stuff that Shockett filed, all the stuff that Bubbles filed, all of that right there is nothing but bolstering, and the judge isn't having any of it. Judge said no. That's all he's saying is both you guys. Yeah, I will strike every single thing that you file until you get leave of the court to file something, because successive motions for summary judgment are disfavored and not allowed as a right, and piecemeal litigation wastes precious judicial resources. In other words, judge is saying, I don't want to read your bullshit. Simple as that. I'm not reading your bullshit, either one of you. And if you try this crap again, I want to slap down both of you. That's exactly what he's saying. So don't get all worked up that he's going after one person or the other. He's telling both Shockett and Bubbles that you filed this stuff way too soon. Stating that successive motions for summary judgment are disfavored and allowed only with the court's permission, and striking a plaintiff's successive motion for summary judgment under the court's inherent power. Okay, he's telling you exactly why he's doing it, because it's the court's discretion, and he's telling you we're only going to strike down what I'm telling you. Don't do this crap again. Absent express approval of the court upon showing of good cause, the parties in this case will each be allowed to file a single motion for summary judgment. Now they can file other motions, like the motion that Shockett filed today. All right, the thing that Shockett filed was in response. He's not striking that out, as you'll see in his strikes, because that wasn't included in his strikes. Doesn't mean the judge can't come back later and strike those, but he's going to allow a single motion for summary judgment by the dispositive motions deadline. And that deadline, I believe, is April or August. It's April 23rd, I believe. He does say exactly when that dispositive motions deadline is. I believe it's in April 23rd. Explaining that a good reason is needed for district court to allow a second summary judgment motion. Any motion for summary judgment must comply. Now, this is very important, and both these folks should be very paying close attention to this, because it says any motion for summary judgment must comply with the word limit and evidentiary requirements set forth in the local rules. And that is setting an 8,000 word limit for summary judgment motions and requiring the moving party to file any supporting evidence not already in the record. Okay. Hey, thank you very much, Vicky. I'll get to your super chat here in a bit. I will. I promise. I'll get to that super chat. I wanted to get through this particular pleading, make sure that I've got this done of what the judge's order was. Accordingly, it is ordered plaintiff's motions for summary judgment and supporting memoranda, which are these documents right here, 73 through 77, are stricken, which means he's striking every single one of those documents that we read the other day. Now, prior to the dispositive motions deadline, plaintiff may file one summary judgment motion that addresses defendant's counterclaims and plaintiff's claims if plaintiff believes that the summary judgment is warranted on his own claims. Okay. He's saying he's got one shot at this. All right. This is what will happen. He's trying to get this case thrown out last night. He said that they believe the judge is going to dismiss the case. Yeah, I don't believe here's the thing, Debbie. I don't believe a single word that the Cankle twins say. I don't believe a single word that they say, because they have lied their way through life for so long that anyone that tries to even attempt believing a word that they say will be sadly disappointed. Because let's see, they didn't live at a certain place. That wasn't them. They weren't in that particular area. They got the wrong person. They were never served properly. I mean, the lies can go on and on and on and on. So I have very little faith in what they say to be true. That they never raised money for X, Y, or Z, but they had to purchase new equipment because their old stuff died. Yeah, 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 yeah. Bubbles sticking to an 8,000 word limit. He'll lose his ever loving mind. Yes. All right. If plaintiff believes summary judgment is warranted on his own claims, plaintiff's motion for summary judgment must comply with that 8,000 word limit and the local rules of the Northern District of Florida, which means he needs to make sure that it sticks within all of those federal rules and the local rules of the Northern District of Florida. And he's going to be doing all kinds of double checking. I'm positive on that, because you're going to want to make sure, both sides are going to want to make sure that you stick with those rules. So all of the little snide comments that Bubbles likes to make there, he needs to stick with the law and get off his little high horse and stop snorting on the glue. Prior to dispositive motions deadline, defendants, now he's going to the defendants part right here, may file one summary judgment motion that addresses plaintiff's claims and defendants' counterclaims. If defendants believe summary judgment is warranted on their own counterclaims, defendant's motion for summary judgment must comply with the federal rules of civil procedure and the local rules of the Northern District of Florida. Now, here is where it becomes very important, because the judge is saying no party may file additional motions for summary judgment without leave of the court upon showing of good cause. So what he's saying here, before you file another motion for summary judgment, unless you have good cause for filing a motion of summary judgment, I don't want to hear it. That's exactly what the judge is saying. He's saying it to both sides. He's not saying it to just one. So ordered 19th day of February, Zachary Bolitho, United States Magistrate Judge. And he's very adamant about this. You have to remember, the judge isn't going to play. This judge has become very clear that he's not playing around with anybody. He is being very specific. He's being very meticulous and making sure that he's not currying favor to one person or the other. Darlene goes, I guess we'll find out tomorrow. Chances are he probably hasn't. Well, and I don't know. It's certain states, and I'm just saying certain states have different rules surrounding this. Different states have different rules, different jurisdictions. It could be he has until midnight tonight, which would put him, he's got another hour to hand over all that stuff. It could be that the judge is saying, listen, they may say, that's fine. You got it in the next day, but I would assume that Randy's got some sort of paperwork already together if he doesn't hand over discovery. I would assume that that's already been created. I mean, that's usually how things go. I mean, because he's anticipating that Bubbles isn't going to hand over that discovery. Don't know that, because I wouldn't know. How would I know what anybody's plans are? What is a 73, 74, 75, 76, and 77? Now, those were the pleadings that were, because that's a very good question. Those were the pleadings that Shockett filed over the weekend in a response to the ridiculous filing of what Bubbles has previously filed. So those right there were completely shot down. We read those over the weekend. I believe it was Saturday or Sunday. I forget. But those, maybe it was Friday. I don't know. Time is a weird constraint. I couldn't tell you exactly what day it was that we did that. But we read over those pleadings. Every single one of those, the judge just shot them down. Like we're cutting those out. Well, what if she threw away everything and Deuce has nothing to hand over? Well, then that would be improper. That right there would probably get her a big fat sanction, because there is always something to be handed over. Okay. There's always something to be handed over. And I'll explain to you here in the actual motion that the judge granted. Okay. Give me just a second to pull this thing up. I'll have to find it really quick. That is a really good question, and I want to address that. Open, hell is it? Da, 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 da. It was, I believe, in 67. Is that right? Nope. All right. So the one that was addressed, a second, I'll close this really quick. I want to close some of these documents because there's so many of them. Okay, the one that was addressed today is that one. And then the judge's order, I believe, was this one here. Nope, that is not it. Tab. Let me find it really quick for you so I can explain exactly what it was that the judge said. I want to double check and make sure that it's correct. Close the current tab. And I thought it was 64, but it's not. It's not it, but I can close that one there. And 62, 20 a day. Nope, that's not right. And 61, 60. I'm looking through these to make sure I've got the correct document, because the judge was very specific about what he wanted them to hand over and when it had to be sent out. Is it 69? Is that right? No, that's just an answer. 69 is just an answer. That's all that is. Uh, 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 68. Nope. 67. Nope. And 66 maybe. Yes, it is. There it is. That was the one I was looking for. It is document 66. Okay. Document 66. Very, very specific on this one. Well, as much as he could be. All right. Let me share this with you guys so you have exactly what I'm showing. There it is, right there. Okay. So this particular order right here was the motion to compel production of documents 52. Defendants have responded in motion. Opposition of 59. No hearing is necessary. It's ripe for resolution. The defense with request for production of documents, document 52-1. Defendants responded, December, blah, 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 motion to compel, general objections, discovery requests, all of these things arising, which, if I'm not mistaken, let me get down towards the very ending of it. Request of productions for number 5, 11, and 12 does not completely end the matter. Let's get a little bit further in here because this was what the judge had to say. The motion to compel documents from document 52, and let me pull that one up. So it tells you exactly here what was suggested. And we go down here, memorandum and support. Document 52, discovery responses. All right. So he's basically chastising him for this horrible crap that Bubbles filed right here. Request for reasonable fees and costs, and the judge turned down the fees and costs. Give me a second, because I believe it was 52-2. No, that was not it. It's 2-1 maybe. Yes. Okay. So it is this one right here. All right. So this tells you exactly what he's requesting. All right. So you're asking about what if she deleted things? Well, here's the thing. You have to pay close attention here because this is the important part of it. Okay. This request requires production of documents or things in your possession, custody, or control, and for documents or things that are in your possession, custody, or control of your agents, employees, accountants, attorneys, representatives, or other persons who have documents deemed to be in your possession or custody and control. And let me go ahead and get a couple of super chats here. I want to make sure that I don't, because I can only go back so far. Hysterical, you read perfectly. Thank you for the laugh. You're welcome. Welcome. And I'll get to yours here in a second. I've got one up here. Boy, you guys are just like flying in here with the wonderful chats. I love you guys. You're awesome. Okay. Let me see. We've got chat, repercussions. I do think she sees what sort of thinking, Randy. God, chat, you are just on fire tonight. Absolute fire. I'm a genius with my responses. Yeah, thank you. I appreciate it. And internet will be forever. Be mean to him. Nice job. Appreciate it. And it's all supposed to be fun over here. We don't like getting too bent out of shape here. And let me see. All right. So we've got Vicky Brushwood. Thank you very much for the $5. I appreciate that. That is from Vicky. She says, hysterical. You read perfectly. Thank you for the laugh. I enjoy making people laugh. I get a big kick out of doing this stuff myself. That is for you right there. Thank you so much. Right on the base of my skull. Appreciate you. Thank you. Thank you very much, Vicky Brushwood. And I believe there was another one in here. Let me make sure that I get down there to it. Boy, this isn't as easy to use as StreamYard. Nope, that was it. If I missed a super chat, I do apologize. I thank you very much for that. It does keep the lights on in this naked place. Okay. So the question was, what if they don't produce it? Okay. Now he's stating all of the stuff that should be here. Now, if any objection is made to any documents or requests, the objection will state with specificity of all grounds. So if they're objecting to not having the document, they have to be very specific of why they don't have that document. Hey, Mayor Dan, how you doing? Good to see you. Fine, sir. All documents must be produced as they are kept in the usual course of business or must be organized and labeled to correspond to the categories of documents requested below. If any information is withheld based on a claim that is privileged or otherwise protected from disclosure, you're requested to furnish a list specifying each document for which that privilege is claimed. Okay. Now, the reason, and they have to turn over all these documents. They have to turn over all these documents. They can't just say, oh, well, we're not going to show you that because it's blah, blah, blah. You have to identify the document, which means you have to have that document. Then you have to identify it. And then you have to furnish a list specifying each one of those documents for what is claimed. And with that information on that document that you're withholding, you have to have the date appearing on the document. If no date appears, the date which the document was prepared, the name, the persons by whom the document was prepared, and if the document is signed, the name of each person who signed the document, the name of each person whom the document is addressed. So if other people have a copy of this, then you're supposed to name them. the name of each person other than the addressees identified in above, whom the document or a copy thereof was sent, or with whom the document was discussed. So, say, for example, just use this as an example. Imagine that I've I have I have not had a copy of the document, but the document was discussed between me and Tug, for example. I would have to disclose that I discussed this document with Tug, which would mean that that would not be a privileged document. Make sense? Name of the person or persons who currently have custody of that particular document. The specific grounds on which the claim of privilege rests. So if, say, for example, and I'm just using Tug as an example here because he's easy to pick on. Name of the persons who are currently have custody of it. I could say, well, Tug has custody of that document. Or I could say that my attorney has custody of that document. The specific grounds of which the claim rests. You have to be very specific on what grounds that is. The paragraph or subparagraph of this request to which each document responds. The general nature of the document, the number of pages which it consists, it could be 1 page, it could be 100 pages, and a sufficient description of the subject matter of the document without disclosing the document. You could say that the document contains, how many times I take my birth control pill or something like that. Just using that as an example and say that's, privileged information between me and my doctor. To allow its description to the court for ruling on privilege of claim. As to the request that is claimed to be overbroad or seek irrelevant documents, please indicate whether any responsive documents or subcategory of responsive documents are conceded to be discoverable and the identity of the documents or subcategory of those documents that will be produced. That's still a little broad, but that does work. The judge approved it. As to the request that is claimed to be unduly burdensome, expensive, or oppressive, then you have to provide the following information: the number or volume of responsive documents, the location and manner in which the documents are maintained, whether they're on a hard drive, a flash drive, if they're paper documents, any particular unusual burden or effort required to produce the responsive documents. I don't have enough paper in the world to produce all the documents could be a valid excuse. But you could, you would have to provide proof of that, saying, it's 6,000 pages and it's overburdensome. Estimated cost of producing the responsive documents and any other facts which you rely on to support your claim that production of responsive documents is unduly burdensome. For the requested documents that are no longer in existence, and this is where it gets to your point of what if they say they don't have any or they cannot be located. They have to identify and describe the document as completely as possible. State when and how the document passed out of existence. Did you destroy it? Just saying. Or why it can no longer be located. Oh, well, I don't own that computer anymore. And then you have to state whether the document was lost, destroyed, discarded, or provided to a third party. And if a third party had any copy of it, you have to identify that third party. And then you have to identify each person having knowledge concerning such a document and state any additional information that you have concerning the current document's whereabouts. You could say it's on a hard drive, on a computer, sitting in a dump in Iowa. Wouldn't matter as long as you're providing that information. You have to provide the information. You can't just say, I don't know what happened to it. That's not going to satisfy. And that can be used against them in court. So whenever you're asking about that, that can be used against them in court. Because they can say, listen, they're telling us that they don't have the documents, and we know that they had these because we have proof that they had these. And here they are saying, oh, we can't produce those documents anymore. And that will look very poorly on them. They would not be requesting these documents if they didn't have copies of them already. But this right here goes to show the kind of people that they are. There's a big possibility that Jeremy has a copy of everything that they've produced. All of the bullshit lies, all of the stories that they've told, all of the little screenshots of them saying that they've got this and they've got that. If I'm not mistaken, not too long ago, they were saying how much information that they had that they were going to bring down Shara, that they were going to go after her and attack her, calling her a liar, and that they had proof of this. So now they're going to have to provide all of that proof. And if they don't, they have to provide why they don't have any proof of that anymore. And that can be used against them in court. Oh, I hate for the little girl to be homeless, but I hope LMOP has to sell a property page. That bears no relevance to me on that. I hope that that child is safe. That's all. I mean, I can't say anything because I don't know anybody personally, but children don't deserve any bad things to happen to them. Any document bearing any marks, including but not limited to initials stamped incendia, I'm not sure what that is. Closed captions or CCs, I guess, like forwarding on documents, comments, or notations not part of the original text or photographic reproduction thereof is a separate document to be produced. So if they've got it's, and what he's saying here is, say for example, I sent an email with that document and I CC'd it over to him and to Tug and to Jeremy and to Bubbles. Each one of those people would have to produce that document down that chain to prove that it's the same document. That's all that they're saying right there. So if you CC'd somebody on it, it has to be produced. Each one of those has to be produced. Whenever a document is not produced in full, state with particularity the reasons why it was not produced in full. For example, you had to redact something because this part was attorney-client privilege. You have to put on there this portion of it was attorney-client privilege. And you would still have to, you can't just scratch it out and then hand over the document, because the judge may want to see and confirm that it is actually attorney-client privilege because he's got nothing to win by it. With as much particularity as possible, those portions of the documents. Now, if they have a mole inside their ranks that has copies of these documents already, oh, that's really going to hurt for them. Like, just imagine that, though. I mean, I hadn't thought about that, but if for example, if they do have a mole, like it's been talked about, then they possibly already have a copy of those documents. And them not producing those documents, if it's shown that that mole has copies of those documents, and they try to hide that, oh boy, that's not going to look good for them. Those portions of the documents that are not produced, including the content or substance of the content thereof. File folders are to be produced intact with the documents. And this goes to, he defames Jeremy all the time. Very true. Happy Witch watched it recently, hearing exactly how they could twist things and who would believe it. And the people would be on Tug Amazing. Shizzy's channel and What the Hell's. Even I was surprised. He defames Jeremy all the time. Yes. And I don't think anybody's sending any super chats. Okay, we're good. Documents attached to each other should not be separated. So think about this. Whenever Lynette showed up into court with that big stack that she said, I have all this proof of what Jeremy did, blah, 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 part of restraining order, anything to do with this, that's part of it. That has to be produced. That big file folder that she had has to be produced. Computerized information and electronic records are to be produced to an intelligible and readable format and are to be accompanied by a description of the system from which they were obtained. Are they from paper? Are they from a USB drive? Are they from a hard drive? Do they come from a tablet? You have to give a description of it. Words in the singular, including their plural meaning and vice versa. The conjunction and the distinction or shall be individually interpreted in every instance as meaning and/or, and shall not be interpreted to exclude any information otherwise within the scope of the request. Pronouns shall include masculine, feminine, neuter, singular, and plural as required by the context in which it was used, and shall not be interpreted to exclude any information otherwise within the scope of the request. So I hope that answers your question. I know it's a long way of getting around to it, but that right there is what these documents are being requested from. So whenever you were that question that you were asking, how do you know that they don't destroy the documents and then they say we don't have anything? Yeah, they have to provide proof of those documents being destroyed and what was the contents to the best of their recollection of what was in those documents. Yeah, this is one of those where you don't play around with a court like that, because whenever you're in discovery, there's there's like a 90% chance, if not higher, that the other side already has copies of those documents. They already have the proof that you've stated that you have those documents and stated where you had those documents and what you did with those documents or what you were going to do with those documents. And there's also a very high probability that you've got someone in your ranks that's telling the other side exactly where those documents can be found. And so if you come back and say, I can't get that for you because that doesn't exist, guess what? Guess what? That doesn't absolve you from it, because there's going to be somebody in their ranks that's going to look at it and go, guess what? They said that they still have these documents, and I know exactly where they are. And then whenever they get called in to testify, then an attorney's going to get sanctioned. Then the defendant's going to get sanctioned, and they will get in all kinds of trouble. That's why it behooves you, as one of these idiots, to turn over everything. I think downvotes show the channel is relevant. I guess. I don't know if I'm relevant or not. I'm just talking. But BBB went on the haters group and asked how does he get all this information? One, he doesn't. Yeah, it doesn't matter. It doesn't matter. It doesn't matter what he thinks about this. This is what is required by the court. This is what the judge requested. This is what the judge told them that they have to do. They have to comply with this. Don't go there anymore. Tug, Megan, other channels to have fun videos to make you laugh and smile. Exactly. That's what we try to do. Put a little smile on your face and have fun in life. Being over there, they're just upset. They're very upset because they've been doing the really bad shenanigans, thinking that they could get away with it. The only problem is they're used to picking on people that don't fight back. So whenever people have had enough of it, they tend to fight back. And that right there, like man, and I'll use myself as an example in this situation, because before I started even following the federal case, because I wasn't following the federal case from the beginning. It wasn't something that I was really looking at. What I was following is I was following Judge Grudge. I was finishing up the deposition. I think I had maybe 2 more to go on Lynette's deposition, like 2 more hours or something like that. And then I had Bubbles reach out to me, telling me that I had it all wrong, that I needed to cover it a certain way. I guess he was jealous of the amount of views I was getting. I didn't really pay too much attention to the views. I look at, how many people come in, hang out, watch, and enjoy the stuff that I'm talking about, enjoy the music, enjoy the laughter, the fun, the mocking, the sarcasm, the not taking myself too seriously on any of this crap. I was That's what I enjoy. And whenever he sent that to me, I responded in my normal way. And I sent that because I didn't know anything about it. I had no idea who these people were. I sent it to I think Megan at the time, because I wasn't really in contact with Tug. So I sent it to Megan, and she told me that they were covering this federal case, and did she mind if if she read it on a stream? And so I was just like, yes, but there's some people that are on that email that I don't know if they would appreciate having their name spread out there. So if you could just remove their name off of it. And they say, oh no, we redact all that stuff out of there. But if you don't mind, we'll read this on stream. And so they did. And then the vitriol really started from Buttons. And whenever that started, I wasn't going to let it go. And that's how I got involved in all of this. Love the letters you've written. Wonder how many Bubble actually reads and how you know Tug. And yes, and Tug is awesome person. I mean, I've known of Tug for quite some time. I mean, you know, the depth trial. I was watching Ricada and listening to it then. I you know, Ricada is the one that drew me into all of that because I think it was watching him during Rittenhouse and then the depth trial was what really like sort of got my interest peaked. Like, oh wow, there's actually people there that are making this interesting. And that's what really drew my interest. And that's how I was introduced to Tug, you know, the same way as a lot of you people possibly would have been. And I found him very entertaining, very knowledgeable about what the subject matter was. So I've been following Tug for quite some time, but you know, I'm just I'm just a little old me, nothing spectacular. Um, and have enjoyed, you know, getting to know Tug and having, you know, conversations with him outside of this stuff too. So that's always been like really because he's, you know, he's pretty no nonsense. Whenever you get to know him, he's pretty no nonsense. Um, and I would consider him, you know, an acquaintance, a really good acquaintance. He's, you know, he's always been absolutely accommodating, kind. Um, I couldn't say that we're friends because we don't know each other that well. It's always in conversation that we have, but I'd like to think that, you know, we've been friendly to each other and there's no animosity that I can think of. Um, and and I got to know Megan a lot better. Got to know her quite a bit, a lot better. Which I think that, you know, she's an absolute special kind of person, which that's hard to find in this kind of space. So yes, that's how I got involved in all this stuff. Now you're gonna get me all like teary-eyed and stuff. J Mac, wow, Muggies is hanging out here as she hugs me and lays next to you, pats. Sorry, Yankee Bell. Tug always redirects us to you. Oh, I know, and so does Megan. I mean, like I said, they've been just like the kindest and more ways than one. You know, we're talking about outside of the YouTube drama stuff. They've been like some of the most kindest people that I've run across. And I think I know Megan a little bit more than I know Tug, but I understand why, you know, Tug is Tug is very protective of himself because he's been burned too many times by other people. So I understand that. And you know, he's also helped me out on the YouTube stuff, like giving me pointers and pointed out things where I can improve. And I always take that to heart. I don't always follow it, but I do take it to heart. uh, I'm hoping that you know, we've got he's talked to me about covering a little bit more of another subject that's involved in this, and I'm totally down with it, but there's just never any time to go over it. And whenever we do, it's going to blow your minds away. I will tell you. It will surprise you. It will surprise you to no end. You're going to go, "Oh, I had no idea." I mean, you'll suspect it, but you'll have no idea. But he's always been very accommodating and one of the kindest, most caring people. You're 100% better. Owe it to you. Oh, awesome, awesome. Okay, now that you guys got me all like thinking about how awesome everybody is here, I thought you'd have like thought your tablet across the room and cried for a few minutes. You're 70 years old, acting like a 5-year-old. Oh, don't you be crying. Yeah, no, I wasn't about to let it go. It's one of those where whenever somebody starts coming hard at me, then I know that I'm hitting a nerve, and I'm hitting I'm talking about things that I should be talking about, especially if they're so vehement against the things that I'm saying. Um, I know that I'm hitting a nerve, and I will, continue on until I can't. That's just me. You know, I'm a bit of a fighter in that kind of aspect. I don't like to back down. You know, you come at me, and I feel the need to defend myself, defend people around me, and and just be want everybody to get along. I want everybody to be happy, have a good freaking time. That's the biggest thing. I mean, if you haven't seen us reading the depositions, I've got Volstorm, Dictionary Diva, uh, Yamaha Biker. Thank you so much for that right there. That's for you right there. $2 from Cynic and Chief, Shissy, Magtug, Smug. And we had a great time doing that. That's more of what my channel is about, is having those does what not sells. I don't know what you're saying. All hails does what not sells. I don't know what that means. Smug, that's classic. Yeah. Or it could be Tuggums. I don't know. It could be anything. They're not pull-up diapers, they're smugums. I don't know. Smuggles. Um, I don't know. I, I'm I think that I like to have fun here. I like to find the absurd and be sarcastic. And I try not to be too serious about anything, especially myself. I don't know. I'm a weirdo. I guess is the best way of putting it, is just being a complete weirdo. Just I guess it's okay. I guess it's okay. I don't know. The helmet was because, like I told Bubbles, I'm an artard. You know, I'm not the most brilliant, I guess is the best way to put it. So for him to get beat down by someone that is on the lower level of riding the school bus, usually, grabbing hold of the bumper and holding on for dear life, to get beaten down by him must just really, really drive him up the wall. Must make him feel small and useless, but it's okay. It's okay. He'll feel better after all this is over, and he moves on to other greener pastures, and stops sniffing up my leg, like a horny dog or something. He'll do much better. I really don't know what I would have done without all of you. I truly mean that. I have so much respect for all of you. Oh, thank you, Debbie. We just the helmet is for protection from slings and arrows. No, that's what the hands are for. Uh, I have Artard strength. Did I just hear smuggle snuggles as it came back in the room? You probably did, Heidi. That's probably true. Megan would cringe. Yeah, Megan would cringe. I make Megan cringe all the time. It's just in my nature. I say things that are completely inappropriate at the most inappropriate times. That's just me. That's how I roll. I've tried to get a little bit better about it. Have a great way of dealing with Bubbles. I'm glad you won't back down to them. Your emails are magical. Well, thank you, Pickled Tink. I mean, there's no reason to back down. I mean, the threats are not appreciated. I don't take kindly to them. They mm, telling me I can't do something. Now, if I'm in the wrong, then I'll admit, I've been wrong. I make mistakes. I'm only human. Jeez. Sort of. I mean, partially, mostly. I hope all is well with me. Know that hug and love is what I do. I hope so. I try, like I said, I've said this before. I don't have any ill will towards Bubbles. I just think that he's an idiot, and he's he's doing bad things. It doesn't mean that he's all a horrible person and that kind of stuff. I just don't. I think there's always a redemption for someone even as horrible and raunchy as I feel that Lynette is. I think there is some sort of redemption for her out there somewhere in bottom of a bucket, or I don't know. Well, chat. Good night. God bless. Yes, I am doing the same thing. I'm gonna kick this thing down. I want to play the lovely tune one more time. If you guys are up for it, I'll pull up the new one, give it to you, and then I will fire you guys off into ether. So give me a second. Let me pull that thing up for you, because it's gonna be glorious. It's gonna be glorious. I thought that it was fun the first time that I heard it, and I gotta show it again. I just gotta show it again, because it's such a badass song. Don't you agree? I mean, come on. Come on. You gotta love it. Somebody said that somebody put in one of my chats, I don't like rap. It's like, do I really do rap? Do I do that to you? Do I do rap? No. It might be a rap song, but there's more to it than that. A lot more to it than that. Don't you think? A lot more to it. Here we go. Yeah.
Yo, Bruce. You keep catching L's like it's your 9 to 5. Out of weak ass motion, judge said nah, nice try. Courtrooms laughing, Gainesville smirking. You out here begging, but the system ain't working. Bruce hit the court thinking he'd get a dub. Found some weak shit, got smacked like a scrub. Tried moving courtrooms, judge ain't amused. Said we already in Gainesville, why you so confused? Crime by prejudice, bitches your own damn mess. Foul and trash motion, just stacking up stress. Ain't nobody read it, didn't need no reply. Judge saw the title and said denied. Bruce keep crying, but the judge ain't budging. Another bad motion, another ass thrashing. Your dumb ass pleadings make my head hurt. Gainesville to Gainesville ain't never gonna work. Jerk. Jerk. Judge looked at the brief like, what the F is this? No merit, no case, just legal nonsense. Said Bruce, I don't know why you wasting my time. Every motion you file, just weaker than the last crime. Talking about strategy, nah, it's just cope. Like a crackhead trying to sell bars of fake soap. Every single move, just a courtroom joke. Denied, stamped hard, now your ego got choked. Bruce keep crying, but the judge ain't budging. Another bad motion, another ass thrashing. Your dumb ass pleadings make my head hurt. Gainesville to Gainesville ain't never gonna work. Jerk. Yo, Bruce, what's next? Gonna file again? Trying to move court to the effing Caribbean. Judge don't care about your salty ass tears. Gainesville's locked and say goodbye to your fears. Goodbye to your fears. Say goodbye to your fears. Goodbye to your fears. Mig Philip and Paint Chip, they riding your wave. Both looking desperate, trying to get paid. But this ain't no payday, this a legal beat down. You a joke in the system, a certified clown. Shock it, just styling, dunking on your name. Each motion you write just fuels this game. Stop filing this bullshit, take the L with grace. Lady Doreen finna body bag your whole damn case. Bruce keep crying, but the judge ain't budging. Another bad motion, another ass thrashing. Your dumb ass pleadings make my head hurt. Gainesville to Gainesville ain't never gonna work. Jerk. Take the L, sit your ass down. Keep sitting there mad, looking lost in denial. So next time you think about dropping some trash, just remember Judge Minty Fresh gonna put a boot in your ass.
your ass down. Keep sitting there mad, looking lost in denial. So next time you think about dropping some trash, just remember Judge Minty Fresh gonna put a boot in your ass.
Oh, you thought I was done, bless your heart, but I'm still living rent-free, it's a work of art. Call me daddy, call me nut, call me the goat. You're paddling upstream while I'm running this boat. You say, I don't care, yet you're glued to the screen, caught up in my glow while you stay unseen. Your shade's like a breeze, it's barely a draft. Meanwhile, I'm the Picasso of roasting your ass. You say you're over me, oh how cute, but here I am, still the star of your loop. You're my biggest fans, don't even deny, so grab some popcorn when daddy goes live. Call me daddy, yeah, shout it loud. King of your thoughts, I'm making you proud. Papa Nut, Shizzy Daddy, headline act. Your background noise, and that's just a fact. Let's face the score. You hate that you love me, but you keep wanting more. You're like a dog chasing cars, you don't know why. But here you are, barking while I touch the sky. Your comments are gold, such comedy gold. Who hurt you? Oh wait, it's me, I'm told. You're keeping tabs like an unpaid intern while I'm cashing checks. When will you learn? Your timeline's a shrine to every move I make. I'd say thanks, but you're a nasty skank. Oh, Shizzy's washed up. Yeah, sure, Jan, yet here I am, the centerpiece of your plan. You hate watch my stream like it's Oscar night, but guess what, kiddos? I'm still shining bright. Call me daddy, send in your bread. I'm still rent-free in your effing head. Papa Nut, Shizzy Daddy on your brain. I'm your mental landlord, you can't complain. Let's keep it real. You hate that I'm winning, but you love how it feels. Oh, I'm sorry, did I break your streak? You tried to ignore me for like half a week, but daddy's too spicy, you can't look away. I'm the train wreck you need every single day. So while you're out there with your plastic clout, I'm here sipping coffee watching you freak out. You're irrelevant, wow, what a take. Now go rewatch my vids while I count how much I make. I count how much I make. Call me daddy, yeah, own it now. I'm reading your brain and you don't know how. Papa Nut, Shizzy Daddy, let's set the bar. I'm the constellation, you're a burned out star. Embrace your role, cause I'm the main character. You're just an old ragged ass, burned out troll. So that's your bedtime story, kids tucked in sweet and snug. Shizzy Daddy's forever, you lose and you're stuck in the mud. Now say goodnight to Papa Nut, your mental plane. Oh wait, you will see me tomorrow's. Jundam will see me tomorrow, same obsession, same effing thing.